informal amendments or changes to the Constitution are not as easy as the formal changes. Formally, we know that there are 4 different ways to change the Constitution, and there's been 27 changes or formal amendments to the Constitution. But informal is a little more subtle, and when we're looking at the Constitution, it is a living document, and some people like to say, no, it's not a living document, it was just made the way it is, and that's it. But with the Clause 18 in Article 1, Section 8, Clause 18, that's the implied powers clause. Congress shall make all laws necessary and proper. This elastic clause stretches the meaning of the Constitution. So if, say, for an example, one of the powers of Congress is to coin money, one of the powers of Congress is to tax, one of the powers of Congress is to create weights and measure for the dollar and so on like that. And then one of the powers is to borrow money. Nowhere in the Constitution says that the U.S. government or federal government can create a bank. Well, it was implied through those expressed powers that the federal government or Congress could create an actual bank. And they created the first bank of the United States, the second bank of the United States. And through an amendment, we created the Federal Reserve System. But that implied power was upheld with McCulloch versus Maryland and some other court cases that Congress did have the power to actually establish a bank. And that was an implied power. So implied powers allow the federal government to expand or grow. There's also things like George Washington did 2 terms as president. Now, nowhere in the Constitution at this time was there a term limit for president. But since George Washington did this, and he was our greatest president and our hero, all of the other presidents after that, up until Franklin Roosevelt, till 36, did all the presidents actually just do 2 terms, and then they just kind of resigned or didn't run again. So this was an informal power, and basically it's an informal change, to the Constitution. So this was not written in the Constitution, but it was just done by tradition. We also have the tradition of senatorial courtesy, where the president will ask the senator of a state that he's nominating a justice to the courts, and he'll ask his opinion. So senatorial courtesy is another informal change that's happened. Laws made by Congress can informally change the Constitution or the meaning thereof. So there's a lot of different ways to informally change the Constitution. Another one is Supreme Court cases. What is the meaning of a section of the Constitution or an amendment? And it changes over time. So in the beginning of our Constitution, we basically said Congress shall make no laws that basically restrict the freedom of speech. And that was for Congress, and that's how it was read. And we had Barron versus Baltimore, which basically said the Bill of Rights was for the federal government and Congress, not the states. So the states did not have to worry about making laws restricting freedom of speech, freedom of religion, and so on. Well, with the 14th Amendment and in the 20th century, Supreme Court courts have actually said that the Bill of Rights does apply to the states. So this is a change. We also had, Plessy versus Ferguson, that separate but equal happened, and then Brown versus Board of Education in 1954 said separate but equal is not acceptable. So Supreme Court cases can change the meaning of the Constitution and update the plan of our government. Up until recently, gay marriage was not allowed, and now it is allowed. You have different Supreme Court cases that do affect laws and affect the meaning of the Constitution. So informal changes can just be like tradition. It could be by a law of Congress. It could be by a Supreme Court case. It could just be a lot of different ways. So this seems to be the preferred method of changing and having the Constitution grow versus doing a formal amendment. A formal amendment is very hard to do. It requires federalism, it requires congressional action, where it requires 2/3 of Congress, House and Senate, or 2/3 of the state legislatures, and then it requires 3/4 of the states or 3/4 of the state conventions or constitutional conventions to approve this. So it's hard not only to get Congress to agree on something with 2/3 of a vote, but it's also extremely hard to get 3/4 of the states to vote and agree on something. That's why there's only been 27 amendments, and some of them were, the first 10 were done right after a requirement for the Constitution, and they've been few and far between. The last one that we had, the 27th Amendment, was in 1992, and that was an amendment that James Madison actually proposed back in the 1780s. So this is about informal changes to the Constitution in informal ways to modify the Constitution.